Now for this morning's second plenary session, we'll be examining the past evolution of the family court system and what likely direction it will take in the future. And I want to introduce Professor Andrew Shepard, the plenary's moderator. Andrew Shepard is a professor of law at Hofstra University School of Law. He's the director of Hofstra University's Center for Children, Families, and the Law, and the editor, as many of you know, of the Family Court Review. He's the author of the book Children, Courts, and Custody, Interdisciplinary Models for Divorcing Families, a copy of which is out at the book-selling table. And he served as a reporter for the Uniform Collaborative Law Act, for the Model Standards of Practice for the Family and Divorce Mediation, and the American Bar Association's Leadership Summit on Unified Family Courts. He is also a member of the American Bar Association's Youth at Risk Commission, and he's received numerous awards from the American Bar Association and from AFCC for his work with the families and children in conflict. So please join me in welcoming Professor Andy Shepard.
What we're going to be discussing is the evolution of the family court over the last 40 years, particularly in divorce and parenting cases. I want you to get a sense of how much has changed in 40 years. Consider how a hypothetical family would have been treated in 40 years ago if they're getting divorced. Assume they have 2 children and assume that they have some assets. First, those parents were likely to be married. Second, they were part of a fault divorce system. They had to prove adultery or cruel and inhuman treatment to get a divorce. Third, their case was likely heard in a court that dealt with divorces separate from other family problems like abuse and neglect and juvenile delinquency. The assets held in one spouse's name belonged to that spouse. Child support was highly discretionary and there were almost no uniform standards. Maintenance often was awarded for a lifetime. The custody of young children was usually awarded to the mother. There was no special attention to domestic violence. When cases went to trial, each side hired their own psychological expert, and one side's expert did not cooperate with the other side's expert. Dispute resolution was judges making orders. If settlement occurred, it was by negotiations between lawyers. They were represented, and often on the courthouse steps. Today, we've undergone what Jana, who moderated the last session, wonderfully termed a velvet revolution in family law. And for those of you who are interested, that's in the July 2009 issue of the Family Court Review. Parents today are much more likely, in family court, are much more likely to be unmarried and younger and members of minority groups. There are many, many more cases in the family court system. In many jurisdictions, cases are heard in a unified family court, which has broad jurisdiction to hear all matters arising from a family situation, regardless of legal label. No-fault divorce, every place but my home state of New York. Marriage is an economic partnership. Title is largely irrelevant in distributing assets. Custody is determined on a gender-neutral basis and is often called parenting. We assume today both parents should play a role in the life of the child if safe. Domestic violence and safety are a major concern. Parents are not likely to be represented by a lawyer. Most can't afford one. We see increasingly they don't hire them even if they can afford them because they don't trust them. Judges today encourage or order parents to participate in parent education and mediation, which in some states is provided at public expense. It was described in California recently as a necessary public service for the families and children of the state of California. If an expert evaluation is made, it is likely to be by a court-appointed neutral expert. Judges often have case management plans to keep cases moving in some court. And a bunch of new roles for mental health professionals have been created. Parent coordinators. I can't imagine what people would have thought 40 years ago a parent coordinator was. So, our question is, first, the change has been, it's not everywhere at some time I'm positing ideal models, but these are the directions that change has gone in. And the question that we're going to be talking about is, have we made progress? what have been the costs and the benefits of some of these developments and the other changes in family court that the panelists see. And second, we're going to be talking about where we go in the future. What's the direction for the next 40 years? And here to discuss this topic are three distinguished panelists. And these folks are well known to most of you, so I'm going to go light on their bios in the interest of getting to the discussion quickly, and I can shut up. First is Mary O'Connell. She's in red. She's a professor of law at Northeastern Law School, where she heads the family law program. Her extensive family law research and writing have an interdisciplinary focus. In 2006-2007, Mary was a visiting scholar at the University of Massachusetts Medical Center, where she worked with psychologists and social workers of the Child and Family Forensic Center. Along with my colleague Herbie DeFonso, Mary was the reporter for an acronym I hope many of you have heard, FLER, Family Law Education Reform Project, which recommended changes in family law education in law schools to meet some of the challenges of the changing nature of the family court we're going to talk about. Over here is Arnie Scheinbold. Arnie is the managing partner of Rieger, Scheinbold & Associates, which is a full-service, multidisciplinary private practice. He's been an evaluator and a parenting to coordinator, and this is, of course, between us for too many years to count, Arnie. Sure. He's trained hundreds of mental health people and informed lawyers about those roles. He's a past president of the Academy of Family Mediators, the first president of the Association for Conflict Resolution, and currently is an AFCC board member. On my left, far left over there, is Justice James Williams, who's been a judge since 1987. He sits on the Supreme Court of Nova Scotia Family Division. He has an MSW and Masters of Law degrees in addition to his undergraduate law degree. He's been an associate director of the National Judicial Institute in Canada since 2000, where his principal duties have been family law programming. He educates. He's the judge's educator. He's led or been involved with too many family law-related groups and projects in Canada and throughout the country and throughout the world, to mention. As I alluded to in my introductory remarks, the demographics, the characteristics of the people who've come to family court have changed in the last 40 years. Mary, how has that change occurred? Why has it occurred? And how well has the family court adopted to that change?
Oh, good. That was an easy softball question. Can I start by making fun of Peter Salem? No, but I will anyway. Peter Salem named this conference Back to the Future or Full Speed Ahead. Steam, full steam ahead. Peter operates on steam because we're in New Orleans. He used, of course, the dirty word that I was taught 20 years ago by mental health and dispute resolution professionals never to use. Which word is the dirty word? Or. We never say or, either, or, never do that. So everything I want to say today is not about going back to the model that Andy says we've left behind. It's about how you take the best of multiple models, because I don't think any model is ever perfect, and certainly the model the family courts are using now has a lot of imperfections that perhaps we collectively can work on. Now I'll focus on demography. Thank you, Andy. You know a lot of this, but I wonder if you've had the opportunity to bring it together in one place. I'm going to mention three things that I've learned in my research, and I don't do empirical research because I'm a lawyer. I look at what other people do and try to bring it together with a legal analysis, but I've been reading a lot of demography and having students who read it better than I do helping me to read demography, and there's some very interesting stuff going on out there, which, as I say, you in part know, but let me see if I can bring three things together that have interested me very much. One, of course, as Andy alluded to, is the explosion in births to unmarried women. We just got the latest figures from the Centers for Disease Control. Why they keep track of this, I don't know, but they do. And for the year 2007, 39.7% of all births in the United States were to women who were not married at the time of the birth. That would happen to be huge. If we go back to the year 1960, which admittedly is more than 40 years ago, but it was easy to get the number, it was 5%. So we have really seen a sea change in the connection between marriage and birth. A couple of wrinkles on that, and then I'll go on to points 2 and 3. Some of those births, of course, are to women who are engaged in a cohabitation with the father of their child. It is not true that every woman who gives birth unmarried is all alone. However, although increasing numbers of single mothers are in cohabitations seem to be dissolving at a higher rate. That's Larry Bumpus's work. Many people consider him the dean of American demographers. We don't have slides because this is a conversation, but all of my references are in the April issue of Family Court Review, where there's a short article of mine that brings some of this stuff together. So we suddenly have lots and lots of unmarried parents before the courts. Are they different from married parents? I was in a session yesterday where that question was posed to the moderator, and she sort of said no and went on. And of course, legally they're not any different. They have the same rights as married parents. But they may or may not have had, as the gentleman who posed the question said, a trusting relationship at one point. Most people who marry each other, I think, maybe I'm naive, at one point really liked and trusted each other. And maybe you can use that to build on when times get tough. But if people have never had much of a liking and trusting relationship, I would think the challenge going forward would be very different. And that challenge is before all of you in the various capacities that you serve. We also know about unmarried parents, and this is Sarah McClanahan's work, and I suspect hers is a name that's familiar to many of you, that they are less educated as a group than women who give birth while married. So the Murphy-Brown thing, and that's actually the title of Sarah McClanahan's latest article, Searching for Murphy-Brown. You might remember that Murphy-Brown was a television character castigated by Dan Quayle because she gave birth out of wedlock and thought it was a great thing, but she was educated and wealthy, and I think she was like a news anchor or something. Not the situation with most women who give birth without being married. They are a less educated group. That happens to be the variable that's being studied. I think we can probably assume that with less education, they also have lower incomes and a variety of other things, might marry at a younger age, et cetera. Okay, so we've got this huge group of unmarrieds. And that's a big challenge, and I think we need to do much more research on ways in which they might be different from the married parents for whom the original models and the current models were drawn. Number two, and I only have three. Number two is that the characteristics of parents who are divorcing has changed. And this is Stephen Martin's work from the University of Maryland, and he's identified what he calls the divorce gap. David Popenow, the sociologist from Rutgers, who uses his work, also identifies the marriage gap. And it turns out that the women, and they always track women, and isn't same-sex marriage going to blow them out of the water? How are they going to do their work? But they track women, and they figure out what the educational level is of women who get married and the educational level of women who get divorced. Here's what they're finding, that for women with a college education, the rate of divorce has fallen like a rock since the 1980s. For women with a high school education or less, it has either stayed the same or gone up. One quick peek at an interesting study that took a 10-year snapshot. Over a 10-year period, they looked at women with a high school education or even some college, I think, versus college graduates. And they found that in that time period, 16% of the college graduates had gotten divorced, and 43% of the women who did not have a college education. So what are we seeing in the family courts now? We're seeing not only in our non-marital parent population, but even in our divorcing population, a group of people who have less education. I would say you can take credit for that maybe, because I wonder if it means that those people with the advantage of an education are reading some of what you put out about the effects of divorce on children and saying, you know what, I'm just going to have to suck it up because I'm not going to do this to my kids. Last little bitty piece, which has to do with the roles of men and women. This one I really like. It comes from Suzanne Bianchi, who's a sociologist and who does those diary studies and writes about them in a very tedious manner. But we might have suspected that in the past 40 years, men have been much, much more involved in the lives of their children. And guess what? That's true. Fathers are spending dramatically more time with children than they did 40 years ago. Now, here's what we also might have suspected. Mothers are probably spending less time because what we know is they're much more likely to be in the labor force, to have responsible, long hours type jobs. But guess what? Bianchi's work shows that mothers are spending more time with their children than they were in 1960. So here's my final thing, and then I'm going to shut up, or Andy's truly going to kill me. But this is my longest spiel, promise. I worry that we have some really rich, interesting literature on fathers, and I'm so grateful to the people who've done the work and put that out. But if there's a good book on mothers, I haven't seen it, and I want you to tell me where it is. I think with mothers, we got a lot of ideas and stereotypes and not a lot of solid research. And one of the things I think we've all been assuming is that because of the need to work, they're spending less time with their kids, but Suzanne Bianchi says we're wrong. So what do we have demographically? More unmarried people, more people with very little education ground into the family courts, and not a very balanced literature on parents. I'm through.
Jim or Arnie, would you like to comment on that?
No.
The second part of the question, though, which I asked was, those are a lot of very important changes. How well is the family court coping with those changes? Anybody want to take that one on?
Well, I think there's another change that you alluded to, and that is for the family court. We certainly know that in the family court that there are more and more pro se litigants who are coming into the court, and how the court is dealing with those, or how those of us who are collaterals within the court system deal with those, creates a whole new set of problems, both from ethical standpoint, financial standpoint, and an understanding, quite honestly, of roles when they get so diffuse like that.
Could you give some examples, perhaps? Or Jim, do you want to comment?
Sure. I think behind some of what Mary has commented on is changes in the expectation that we have of partnering and marriage in particular. And I think it's Gary Melton talks about it being a shift from social obligation to self-fulfillment. And we see a lot of repartnering in court, a lot of common law relationships. We live in a time when most couples both have to work to make things economically viable. So the adjustments the court has to make when people separate, or the problems the court has, are massive in terms of the economic shifts. And I think that the court system is rooted in a social obligation model that's based on, through good times and bad times, you're going to be together. I sometimes think the vow should be changed until I get tired of you or meet somebody I like more. But today. The serialness of relationships is not consistent with the model that the courts have had in terms of sort of restructuring a family. We don't restructure families. We restructure them, then we restructure them again, then we restructure them again, and then we maybe do it again.
Anybody else want to add anything on this? I have another few questions I'd like to pose.
Well, the only thing I would add to that is it's forcing, because the courts ask more and more from mental health professionals, in a sense, mental health professionals are getting asked new questions, many of which we don't have answers to, although many of which get answered based on value, culture, bias, and not necessarily on research or empirical evidence. So it's also driving us to look at new hypotheses and questions that need to be researched. So it's this kind of reverberating system which is kind of both pushing both fields in new directions, I think.
I would agree with that, but I think one of the self-fulfillment focus in terms of partnering brings to it a question about process, and a lot of people will say to the court, well, did it make you feel good? Are you happy out of it? I can't order happiness. And a lot of therapists can't create happiness in that, but we seem to want to evaluate things in terms of satisfaction and instead of something else, and I don't think that's the right way of evaluating what I do, or for that matter, what mental health professionals do.
I want to ask a question to play off of that, which both of you just said. Mary outlined the changing nature of the family court population. Arnie, you've said it's called for new roles for mental health people. Jim has said, I'm not sure you can order happiness. Is the mix of services, of mental health and services, in the family court now appropriate? Where do you see it going? What, in light of the changes that have been going on? We've mixed a lot of mental health people into the family court over the last 40 years. How is that going, and what should we be doing about that? Arnie, do you want to start with that?
Well, yes. There's clearly a mix in all these evolving processes. So you saw the introduction of mediation into the court system. You saw parent education programs come into the court system. Maybe some sort of neutral evaluation and custody evaluation. And now going to what you said, the advent of parent coordination into one of the new processes. So you see these additive components coming in. And I don't think they're coming in because mental health people have pushed to put them in. I think there exists a void, or the recognition of a void in the legal system to deal with the complexity and multitude of problems that exist for families. And as the court is being overwhelmed with questions that have to do with these complex issues, domestic violence, child abuse, the alienation of kids from parents, the court has had to find other ways to try to deal with the problems. And they've asked mental health workers, whatever it may be, to come in and use processes that exist out there to try to deal with these. Now, that's created problems, but I think that synergy is occurring.
Mary, you want to talk about this?
Oh, I could talk about this for a really long time. I have a lot of concerns about the number of services that judges order. And I want to make this very clear, even though I'm never sure that mental health people who work as hard as they do at what they do can hear me. This is not a comment on the quality of any service provided. But when you hang out in the courts for a while, you can start to get very concerned. And this hooks back into my demography point of the people that are in front of the court having fewer resources, educational resources, financial resources. I see people being ordered to go to parent education, which is actually mandatory in Massachusetts for all divorcing couples with children under 18, to go into family counseling, or to go into therapy, or to go into anger management, or to go into a substance abuse program. And I start to think about, judges, not Jim, judges sort of being like doctors. You see a problem. You see somebody who's sick, or you see that a child is suffering, and your impulse is to do something. And I fear that just as doctors these days maybe over-medicate patients, there's certainly a lot of talk about the number of medications that healthy people are told they should take. I worry about the number of services that families are being asked to undergo. You know, if you don't have a car, if you get docked when you miss an hour of work, taking advantage of all of these services, even if they happen to be provided without cost, is a huge undertaking. So one of my great hopes is if we are looking at a less resourced population, one of the things we need to think hard about is which service is really important for this person to the best I can tell, and not overloading people with a plate of services that becomes really it becomes a downward spiral. They can't do it. And I worry about that a lot. And particularly as lawyers, I know not to speak well of the devil, though I'm dressed like the devil, that without lawyers in there to say perhaps, well, Judge, she doesn't have a car and this and that and that, very often the individual doesn't feel empowered to say that. She's really, or he's really kind of overwhelmed by the whole process. So I do worry about it. And one other point, and this is perhaps me being provocative, which I never am. Actually it was Bob Emery, so I can blame him, at a previous plenary, who talked about the number of people who don't get married. Something that when George Bush was in office was perceived as a crisis, and in fact $150 million of your money, if you're an American citizen and pay taxes, is being spent this year on marriage promotion and marriage sustenance. You can think about whether you want to write to the new administration and suggest that that money might be diverted someplace else. But what Bob Emery said, if so many people are rejecting marriage, instead of saying they're wrong, maybe we should ask them why. And one of the things I worry a lot about is our being wedded to a model of family that it seems to me a whole lot of people are looking at and saying, not for me. Should we learn from that? I don't know.
Jim?
Maybe Mary touched on a solution at the start of her comment when she maybe didn't suggest this, but alluded to me maybe having the authority to order medication. That might... I can think of some lawyers that might be good. Some are present. The kind of marriage and mental health and legal and court services, I quite like Arnie's point that mental health people saying we didn't ask to come to this party, but at the same time, and his point following that these are really complex issues. And I've learned a lot from the interdisciplinary exposure that I've had, and I value gatherings like this a lot. But I think that there's lots of questions that we don't ask. One, the cost of services, which Mary has alluded to, and availability of them. Judges who order counseling when there is no counseling, anger management when there isn't any. Who pays for it? Ask yourself as you look through this program even, How many people could afford the kind of services that are being recommended for different interventions? Two, I think if we look through the past, I guess at this point I'm one of the old farts here, but I think that the mental health involvement in court services, there has been an element, and but there is an element of fad to some of the involvements. Three, I'm always confused, and this is my problem, not mental health's problem, but I'm not sure whether there's been a discussion about whether we want to bypass court or transform it. And that there's an important difference. We heard Dan Goldberg talk about judges need to adjudicate, they need to decide. Well, if you're bypassing court and then just going to court for adjudication, my role doesn't change very much. On the other hand, if you're trying to transform what I do, my role changes big time. And I hope we get a chance to talk about that. Another one, I think in this kind of setting, we don't spend enough time, and in the courtroom, we don't spend enough time distinguishing clinical experience and opinion, which is really important, but is just that, from social science. And I think that there's a distinction. I think there's a real distinction. I think the health-based model makes us think that we can fix everything. When I did my MSW, Thomas Saz was all the rage in terms of mental health. But the mental health model makes us look at individuals in terms of systemic changes. I think of Sweden, for instance, where their parental leave program requires that both dad and mom take some time. Well, what that kind of model does is it builds in from the time of birth an expectation that both parents are caregivers. I think that's a lot more effective in affecting change than us talking about, you should get on an individual basis in the courtroom. Changing people's expectations is where real change occurs. The last thing about the mental health involvement, too often I think we say on the one hand these are really complex issues, on the other hand we silo the issues when we bring mental health experts in. And by silo I mean there are two main issues in every dissolution of a partnership or a divorce or even if people have never lived together, and that's money and kids. And by silo I mean too often we talk about mental health input to the kids and how we distribute the resource of time with the kids and not enough time to the money. And my experience is that people do not separate them the way we do.
Arnie, I think you wanted to say something.
Yeah, I definitely feel that there's a transformation going on. And I would say to you, Mary, that if Bob Emery said whatever he did about marriage and that we need to look at this whole thing differently if people are not getting married, maybe something's wrong with our original model. I think the same is true of the legal systems and the court system's involvement in marriage and divorce. That the transformation we see occurring is occurring because whatever that system was 40 years ago was not working well or does not work well for families who are divorcing. And so with that recognition, we see these evolving processes, none of which are perfect. Each one kind of may come in as a fad, where you have advocates. When mediation first kind of hit the scene, it was going to be the end-all and be-all, and all divorces were going to be mediated and everybody was going to be happy. Well, we obviously know that's not true, and it doesn't work well with certain families. The same, unfortunately, we're going to find out about parent coordination, which is, it sounds great, and it really is a necessary process, but it is not going to be the end-all and be-all for all families. And since we see this kind of continuum from less intrusive to more intrusive, I don't think we're ever going to not have it within the legal system, although I challenged that the other day. But in a transformed legal system, I think the judge's role is changing.
Did you want to say something?
I do want to say a couple of things.
Okay, well, go ahead, and then I'll pose the next question.
I'll go ahead. I want to take issue with one thing you said, Arnie, which is that...
That's all?
Probably several, but I'm going to keep kind.
There is a list here.
You were talking about the family law of 40 years ago not working for families. That might be true. Although I was 20 years old 40 years ago. God. But the change in family law 40 years ago from fault to no fault was not a grassroots movement in any way, shape, or form. And I've written about this. Litigants were not unhappy with the process, which was a totally bogus process. You went in and testified to cruelty that never happened and you got your divorce. The real impetus for changing the system largely came from judges who were miserable at what they were being asked to sit through and thought there has to be a better way. At about the same time, of course, the role of women was changing, and maternal preferences were held unconstitutional up and down. So I don't see it as a grassroots movement. I don't think it came from families. To the second and final point about whether courts can get out of the divorce business, my reason for saying no isn't any great love of lawyers or courts. I love lawyers. I'm married to one. But divorce is a legal process, and Jim alluded to the money pieces. For us to get divorce out of the legal system, we need to remake our benefits system from the ground up. And I'm not going down on a tangent now, but the way most of us get Social Security, health insurance, disability pay, all sorts of stuff, is deeply linked to those people who are defined as members of our families. And when families come undone, somebody has to watch where the benefits go, where the property goes, where the rights go. That's the sort of thing that judges and lawyers spend a lot of their time on. So unless you can remake the system so that people's legal familial status no longer affects their right to very important assets, I think you're stuck with at least some piece of divorce being in the court system. Then that gets to Jim's question of how much do you want to bifurcate? And I'm with Jim. I think maybe we've bifurcated too much. We have a lot of literature that suggests that when a child loses contact with a parent after a breakup, that's very harmful to a child. We have just as much literature suggesting that poverty is about as harmful to a child as anything it could possibly undergo. And we know that a lot of people who are teetering on the brink of making it financially while they're together fall off that cliff when they're apart. So I'm not in favor of bifurcating the child issues from the money issues.
But it shows the need for transformation, because there are lots of, I teach in some of the programs, or I've talked to some of the court-connected mediator programs, and as a private mediator, this is not an issue for me. But in a court-connected program, mediators being told that they can mediate custody but not talk about financial issues at all. Support issues are kind of forced into the very silos you're talking about and put in, at times, incredibly untenable positions in their mediations.
Last statistics I saw were something like 70 to 80% of some divorces occur with one or no lawyer in most urban areas, and part of that is poverty, but part of that being reported is people who could afford lawyers who don't seem to want them. What's going on there? Okay, why has that happened, and what can be done about it, if anything? Mary?
Actually, I heard something really interesting in a session yesterday from a lawyer in California, I think she's in Alameda County, that the statistics on people who come in representing themselves are enormously high, but as people go through the process, if they don't settle and exit, they are far more likely to hire a lawyer someplace through the process. I don't know that that's enough people to really make a difference, but it's the first time I had heard that, and it seems to me that it at least says we ought to look at our statistics differently and see if part of what people are assuming is maybe, well, since we both want to get divorced, this is going to be easy. And if it turns out not to be easy, or even some of the people who might originally have been lawyer rejectors, not becoming lawyer rejectors. Obviously, I'm a great believer in changing the way lawyers are educated. I have the enormous advantage of teaching at this little left-of-center law school where everyone has to practice for a year in 3-month increments before we will give them a law degree. I have an enormous number of people who go through the family law courses and go out to practice family law. I have a former student who's now a judge in the Massachusetts Family Court. In fact, one of my former students was Mary Bonato. You may not know that name, but she brought both the same-sex marriage case in Vermont and won the same-sex marriage case in the Commonwealth of Massachusetts. So we've been at this for kind of a long time. We've been trying to do it in a way that's heavily informed by this notion that we are counselors and planners, but we also have a different role, which is we are there to try to be protective of a certain person rather than having to be a neutral in a process. It is definitely a different role. Why are people not hiring lawyers? I really do think a lot of it is expense. I always say that the best law firm in Massachusetts is Greater Boston Legal Services, and I'm not kidding about that. They are absolutely spectacular lawyers, and they can take your case if you have very little or no money. I think lawyers have priced themselves out of the market. I think something needs to be done about helping these young folks not pay me so much, yeah, as if I were overpaid, not pay so much for law school and therefore be more able to do work for lower income clients. I always give them problems and planning exercises that involve low income clients, and I say you might think that it's the rich people whose cases are challenging, but in fact it's the people who have lots of debts and no resources and other sorts of things. So I think we law professors have an enormous responsibility for turning out lawyers with a different orientation towards family law. And here's the funny thing that happens if you're somewhat successful in doing that. I don't want to give myself too much credit. I think my law school deserves a lot of the credit. But these are people who stay with it for 10 and 15 and 20 years, whereas the attrition out of the matrimonial bar as a whole is extremely, extremely high. So I think we need to learn from all of you how to do our role better, but our role is still a combination of counselor, planner, and making sure that whichever person we have in this situation, that his or her needs are very much a part of every conversation. That's what we do.
Arnie?
Well, I would expand it further. I mean, it's easy because it's commonly seen, this issue of pro ses who, for whatever reason, are deciding to represent themselves. And it may be financial. I see frequently that even people with a lot of resources have gotten tired. Their legal expenses are up over hundreds of thousands of dollars. And even if they have the resources, they just don't want to spend them anymore. But there's another component. There's a lot of people going through divorces who need custody evaluations, who need education, who have no access to those either. Because I think, contrary to the introductory remarks, I think there are a lot of venues where there are no court-connected services at all, where there are, Pennsylvania is a good example. I'm from Pennsylvania. There are no court-connected services in Pennsylvania. There are no access for people to get evaluations other than from private practitioners or mediation or whatever it may be. So it's not just law schools. I think every profession has an obligation to look at how we have a responsibility to help get those services provided for people who need them.
Jim?
I agree that people are making decisions about where they allocate resources and what, in terms of whether they're hiring lawyers. I think that also, I think we've seen a lot of years of, for lack of a better way of putting it, lawyer bashing. And I think that there's, if you look at literature in the family law area over the last 25, 30 years, there's not a lot of respect for what family law lawyers do. And they do a lot of good, and they do a lot of pro se work, and they help the court, and sometimes they're expensive, and the rest of it. But I think that in terms of interdisciplinary gatherings like this, there is perhaps more criticism of what lawyers do and have done than say, mental health professionals. And I think that the media in North America has picked up a lot of that over the last number of years. There's not a lot of good stories about lawyers out there.
I'd like to invite our colleagues in the audience to join us for some questions. Anybody want to take the mic briefly, identify yourself, and direct the question to me, and I'll pass it on.
I'm Mark Wren. I'm a psychologist from New York. If this marriage between mental health and law does last into the future, I think there should be outcome studies so that as psychologists we know what the picture looks like after the ruling or after the court order, short-term and long-term.
Why isn't there enough data, folks? I mean, all of you have variously, and in your capacities, have cried for more data, right? Why isn't there more?
Because someone would have to pay for it. I really think a lot of it is that simple. You know, when psychologists do studies or sociologists do studies, somebody pays them to do it. And if there's no money for the data collection, it isn't going to happen.
If I may, but that would be just a reallocation of money, because without outcome, you do have expenses going into the evaluation, to the court proceedings, lawyers, calendar time, with no idea of how the resources are being spent. So it's very often a blank check, whereas if you do outcomes, you can also do outcomes based on amount of clinician time put in, amount of legal time put in, costs associated. So it's really just going to be a shifting of monies, and probably with a total net reduction once you have more control over that.
Okay, can anybody want to comment on this?
I, on one level, totally agree with the comment. On another level, it comes back to this desire, I think, that we have for a pill or a magic bullet or the thing that's going to fix everybody, or how do we get the perfect outcome kind of thing. And we're dealing with people, and so the science around it is always going to be far from perfect. Again, Dan Goldberg talked about earlier this morning about, don't let judges interview kids until judges can prove that they can do it. Don't let them do it until there's empirical studies saying that judges won't cause any harm. Well, there's no empirical studies saying social workers don't cause harm. So, why hold me to a different standard? I think, again, we all want to do the very, very best we can and with the best information we have. And I'm not saying don't strive for that information or the outcome studies, but I think we have to be realistic about how achievable it is.
I think the outcome studies are very important, and I agree with that. I think it's sometimes very difficult to define the question and to define what you're looking for and to have a design that's really going to get the answers you want. But I think, again, finding the people to do that and allocating the resources for it, especially in the current environment, is a pretty difficult thing.
Mary.
One quick point. I'm not sure I agree that it's just a reallocation. It only is a reallocation if you're assuming that the currently provided services are publicly funded. And frequently they are actually paid for by the litigants. And the litigants are certainly not going to fund an outcome study. So that's a complication and a wrinkle.
Okay, let's take another question.
Yeah.
My name is Judy Krieger, and I'm a family court judge from Miami, Florida. And I want to pick up on a couple of points from the panel and ask you this. After a lot of years as a family court judge, I've sort of come down to thinking that, and this is not a good or bad kind of opinion, but an observation that we are jerry-rigging the adversarial practice that courts engage in North America by bringing in all of these interventions and evaluations from mental health providers, because we are stuck with, I'll use that phrase, the structure, the skeleton of the adversarial model. So, picking up on that, we're in a room without walls, we're all thinking creatively. Should we think more deeply about changing the model? Is this really the best way to handle the dissolving of the status? And I understand your comments, Judge, about the importance of the legal status of marriage, and also your comments about siloing the financial issues from the mental health, from the kid issues, but the kid issues are not really legal issues in most instances. They're more in the mental health domain to me. So I would love to hear from you.
Okay, folks, so the question, if I hear it right, Judy, is what about scrapping the adversary system or rethinking it? Or
is there another model?
Is there another model? Administrative, when we talked yesterday, I said maybe an administrative agency.
Well,
or that's not, I'm not saying there's anything wonderful here, but, well, you guys comment, not me. Sorry.
Or maybe a panel decision that brings in the mental health into the process of decision making if there are third parties who end up having to make the decisions.
Okay.
It doesn't matter who the third party is, whether you call them a judge or a psychologist or a panel. If it's a decision, it's a decision. I think that in terms of changing the system, over the years I've heard my role in places like this described as manager, negotiator, gatekeeper, therapeutic, educator, having special knowledge, and finally adjudicative. At the end of the day, somebody's got to decide some of these cases, even if they are about kids. To me, could an administrator do it? Sure. Is the authority of a court useful in some of these cases? All the high conflict sessions seem to say yes. Has there been for years a struggle to give family law higher profile in courts and to have them in unified courts and at a Supreme Court level? Yes. Are we now going to say, okay, now that we've achieved some respect there, let's knock it to an administrative level where there's perhaps a different kind of status in terms of legal process? If it's better, yeah, let's do it. But I think we need to think about it.
I agree with Jim. I don't think anything is going to change. And I'm
sorry, Mary, I'm having trouble here.
Oh, I said I agree with Jim. I don't think anything is going to change, even if you say the process has been renamed, because in the end, somebody has to have the coercive power. Now, if you're willing to do family in a milieu where no one has the power to, at the end, be coercive and say, no, this money is going to go over here and the kid is going to be on this schedule, then you're really changing things. To me, it seems unworkable. I think ultimately there has to be someone who's been vested with the coercive power of the law. To me, that's the definition of a judge. When someone has the coercive power of the law, that is a judge. So if you're going to keep that in the system, you can say adversary or not adversary. Over the years, I've found that word much less useful. But is there coercive power at the bottom of this? Right now, there is. I think, along with Jim, that there always has to be, but maybe there doesn't.
See, I really frame it differently because I think it's already changing. I think that's what the whole plenary was about, is this changing system. And it's already become more of a hybrid than it used to be. And if one looked at more of the concept of kind of triage system within the courts, there are more or less coercive interventions. And yeah, maybe there has to be, I agree, there may have to be for certain family kind of an ultimate coercive process, but for other families there's no coercion at all necessary. And if we looked at the whole thing as the system rather than just that part as the adversarial system thing, I think we'd have a better view of the transformation.
Let's take another question. Bill, could you identify yourself, please?
Yeah, Bill Howe. I'm a partner in a law firm in Portland, Oregon. We have 23 lawyers, and all we do is family law. A quick comment on people not using lawyers. If you think about it, 40 years ago, folks got sick. You go to the doctor prescribes a pill. You go down, you get the pill, you take it. Now, people are going to the internet. They're going to alternative medicines. I'm guessing a majority of people here are taking vitamin supplements and all the rest of it. So it's not just self-help in the legal field, it's self-help in the medical field and many others. That's part of a more societal phenomenon. Secondly, Jim's point about lawyers being demonized, I think the public doesn't realize how family law lawyers generally have changed, not just in the U.S. and Canada and Australia, but around the world as we travel. People get their legal advice from their drinking buddies and their hairdressers and television programs, and I think that is a component that we might be able to make a change. And many lawyers are doing things like unbundling and the rest, which the public is totally unaware of. Now to my question. The state of Oregon has I think, fairly enlightened family law system, and we stole liberally from our friends in Australia and England and other states around the U.S., and in fact, the first folks that came down were from Canada, to help us construct it. We are now in this economic meltdown. I am on a committee advising our Chief Justice. The budget situation in my state, and I'm guessing in many other countries and states, are such that the analysis begins with what is it that the courts are constitutionally required to provide. And so the question being asked, all right, of all this menu of services, parent education, courthouse facilitators, mandatory mediation, et cetera, which is, Jim points out, Mary, some of which is publicly provided, but often is funded with filing fees, which are also going way up. If you had to trim back, if you were asked by the Chief Justice of my state, all right, you need to cut this budget. We have family courts, we've got drug courts, et cetera, you need to cut 20%. Where do you cut?
20%, folks. Whoa. 10, Bill? Can I go to 10?
Well, the right answer is 0, obviously,
yeah.
Because if you look at the consequence of cutting out this service, but
my other question,
states and provinces all are bound by generally constitutional requirements to have balanced budgets. Well, you can't just close all the prisons. You can't stop paving roads. You can't fire the state police.
Unless you live in California.
Well, I guess
which is what I hear is happening.
One day a week. They close the courts one day
a week in New Hampshire.
Right.
No, I mean, okay, folks.
So I guess what I'm saying is we are in an environment, I think there's general agreement on components of a less adversarial system. Many places have it. How do you manage in a system of shrinking resources, which hopefully is
I think one of the ironies of your question, though, Bill, is you're asking how do we shrink the budget of this less adversarial system, but the budget is of the adversarial system. And I've always found it a little bit confusing that we talk about the adversarial system as if it's some disease, when it's really the umbrella that this is all under. And adversarial, all it means is there's different points of views. And we've used it as a label, and again, this is another issue, I think, with the whole mental health thing, the whole labeling thing. But we've used it as a label to say, oh, that's the bad stuff. Well, you know, mediation is about resolving adversarial positions or different positions in that. So I guess in terms of the question, I think bottom line, people have to be creative. People have to realize that at the end of the day, that adjudicative function for judges is the core. You use the word constitutional service that's there, and there needs to be ways of basically, as the Four Seasons saying, let's hang on to what we got. You know,
I'd go a totally different way. I'd ask for 20% more. I think that family court and families have been underfunded forever, even in the best economic times. I would stay the course and say, we need 20% more no matter what. Take it from someplace else.
Where?
Yeah,
From wherever.
Iraq.
Okay. Let's finish these questions, and then I want to return to the panel. Jeff
Atkinson, DePaul College of Law, Chicago. My question is somewhat the inverse of Bill's. Aside from mediation, is there a particular court procedure or service that you value the most, that you think does the most to help families and to get cases resolved?
Arnie, you want to start with that one?
Well, I think it may depend by jurisdiction. Certainly in the jurisdictions that I live in, just go to statistics for my county, the conciliation process that starts every case settles 85% of the cases. So I guess I would strongly support the initial conciliation process in my county because that works really well. Now we know a lot of cases, most cases settle before they come to the judge anyway, but I would certainly not want to see that one gone.
Jim?
I can't say that I would see one is more valuable than another. I value assessments. I value mediation, our intake process. I guess, and maybe I'm drawn by the mental health thing I've been a little bit critical of. The things I value in our system are the individuals who are skilled as opposed to the service. And this comes back to sort of my pushing back against some of the criticism of judges and of lawyers. I mean, I think there are as many bad social workers, psychologists, psychiatrists, whatever, as there are, quote, bad lawyers, judges, etc. And so in terms of what I value, it's the skilled people, I guess, as opposed to any particular service. Because in any one of those services, I can also identify people who think, please go away. You know?
Mary, you want to weigh in on this?
I don't think there's any good answer because what you want, I think, is for people to have this aha moment where suddenly something that seemed very closed seems open and they can start to move towards a resolution. The problem is that for any given individual and family, that aha moment can come through something completely different. Some people go to parent education, which is relatively cheap, and can be delivered to groups at a time, and you can watch. I've been through it twice now. I've never gotten divorced. I think the Commonwealth of Massachusetts owes me 2 free divorces. But you watch people's faces light up. They've gotten something from it. So it would be very hard to figure out where you get the largest number of aha moments, but I think that would be what you'd be looking for.
Jana, want to introduce yourself?
Hi, I'm Jana Singer from the University of Maryland. So there have been a lot of interesting references to medicine and medical practice this morning. And one of the trends in medical practice is to put more emphasis on preventive care at the front end in the hopes of avoiding some of the serious problems at the back end. And I wondered whether you thought that that's a strategy that family lawyers and family court professionals ought to think more about. We've been very reluctant to intervene either at the time of marriage or at the time of childbirth. But would it be worth trading a little bit of involvement or intrusion at the front end in the hopes that it might avoid some ongoing oversight at the back end?
Prevention.
I agree entirely. I referenced what they do in Sweden with parental leave. I couldn't agree more. Whether it's early intervention with infants or more systemic approaches to this. And I come back, one of the things that I think the really skilled lawyers do more, as much as any of all the interpersonal stuff and the negotiation stuff that we do, is manage the expectations of their clients. If the lawyer who creates a problem in the courtroom for his client usually has not managed their expectations. And I think we can do a lot on a systemic, on a societal-wide basis to manage people's expectations about what parenting is about, who's involved in parenting, and what the expectation is of parenting if you either never lived together or were separated. Again, Sweden, for instance, the state collects child support. It's not between the parties. And the state pays child support. It's a set amount and the rest of it. Well, there's messages there. That takes some of the adversarial thing about it. What people don't like about that is that makes it public as opposed to private. And we tend to define these things as private matters. Well, unless we make them more public at the front end, as you say, I don't think we're going to have really, really significant change.
I
just think it's...
Yeah, I'd like to finish these folks up and then come back for final comments. So let's...
Go ahead.
Okay. Do you have something else you want to add, either of you? Mary, go ahead. But please brief.
My answer to Jana is yes, no, and we already did. Yes, I think what we need to think about is much broader than what's happening in the family courts. People are working with great goodwill to make the best they can out of a mess that's already happened. That's why I want to back up and think about things like, why are so many young people rejecting the concept of marriage, and what does that say to us? No, because I think the Bush administration, as well as polluting a lot of other things, forgive me if I don't sound unbiased, with this, the $150 million that it spent on marriage promotion, it was so right-wing and religious and conservative that it's really kind of polluted the whole idea of marriage education. So in some sense, it's going to have to make some sort of turnaround to become more acceptable. And then the last piece is I keep thinking about the work that shows that the most educated people are not getting divorced. And I feel like to those people who have that privilege, the message about the cost to children is so loud and clear that people have kind of ground their teeth and gotten through bad patches in marriages and woke up one day and said, he really wasn't so bad, and there he still is. So that's my answer.
Arnie?
And again, I think it's a great comment, and I would broaden it even to the fact that it's going to be interesting, and maybe we're already starting to see it, with programs that are in schools for high school kids, with teaching better conflict resolution skills, understanding interpersonal relationships better, understanding relationships they're having. Hopefully that will also be part of that preventive component.
Jan?
Yeah. Jan Johnston, San Jose State University. What I want to ask might sound heretical, coming from myself, who have been an enthusiastic co-architect of many of these programs that have been put in place. But as I see it, what has occurred over the last 30 years is an increasing drainage of the money from the mental health service system and from the social service system in the U.S. And the courts have been induced to take on more and more of a function of what would be those functions of those agencies. People are going to court now when they might have been able to go to a counselor or get services. And the court has become this huge central clearinghouse, a triage center for trying to manage all these problems. Has it not taken on too much, more than what was intended? We are also putting more and more coercive kinds of services into the courts without accountability, without full clarification of what these people are entitled. And as Mary pointed out, often multiple interventions. So what should we be thinking about? I mean, in terms of a real transformation, maybe we should be stripping the courts of these services. Not that they aren't needed; they're needed out in the community, and go back to the fundamental function of what the court is: the decider of fact and trier of pieces of law, which is around abuse, neglect, and issues like that.
Transformation, but please.
Well, quickly, I go back to Arnie's comment that the mental health people didn't ask to come to court, and I kind of feel like, well, I didn't invite you. It's almost like an arranged marriage, and I think, Jan, you put your finger on part of it. A lot of times people are going to court because if the court orders a service, there's either a perception or a reality that the service becomes available in a financial sense where it's not just available in the community at large. And that's a real problem. I don't know how to change that in in these kind of times. But I think I think your question touches on some really important issues in terms of resource allocation within the community. And I have serious concerns about me personally ordering anybody into therapy.
I would say a couple of things. Number one, I think we do need much more work done in the future looking at outcome aspects of this. Research on both whether or not these various processes are helpful, research on what type of combination of processes or interventions are going to be most helpful to these families through the courts and not through the courts. I also firmly believe that this transformation is going to continue to happen because of the needs of people going into that system.